Me mo bi akwaba eba Melodies TV so enra me de 28th May ruling Supreme Court judges by on the Chief Justice Getrude Torkornoo embra wo court awaka say yemfa injunction ento committee ne so na yensan sombo nsem ningu say yepesi yi ne free hono. Me the ruling nearby. In fact, now I have read the rulings from the major rulings from all the judges. Okay, and then me posty Judge Amadou Tanko are the other three judges, and so I agree with Amadou Tanko in the Intine Judge Amadou Tanko, Judge Kofi, Yonu Kulendi, and then Bafo Boni. So they all agreed into one ruling and a medini number. And Rechi, me the judge a J Frempong on also need eba na utie judges na arguments are no more making in ana they were referring to Chief Justice nsem a wode aba beto mu nim what you say enti ehun behia say in details no ye be because we na the proper one say answer na asem ne beba na yet say Chief Justice no akọ Supreme Court but that time na enye the full document enti nsem a wode akọ to Supreme Court nim ankasa ne enim. And so now we are going to read the full document. Chief Justice in the case the other crocodile judges ni mo a judge no e di ruling na wo mo de e ba no e di aba judges ni ruling no you ni na ye hu now ye Chief Justice ni case about the call ni ye say judges ni ruling na wo mo de man no na e se fata so mo man sa ruling no ana say judges no omo anye ni ye. Let's go into the Chief Justice case into any the applicant's case. I say in the affidavit in support of the application deposed to by the applicant herself, she recounted the background to the setting up and composition of the committee currently tasked with inquiring into the petition submitted to the president for her removal from office. She indicated that about the same time she submitted her responses to the petitions, a Ghanaian citizen and member of parliament for the Tafo constituency, Vincent Ekwasefwa, invoked the original jurisdiction of this court for the reliefs endorsed on his writ, and also applied for an interlocutory injunction to restrain the President and Council of State from proceeding with the consultative processes for her removal unto the hearing and final determination of the action. According to the applicant, notwithstanding the pendency of that application, a fact known to the Attorney General, she was surprised to read in the media a press statement from the Office of the President indicating that a prima facie case had been made in respect of the three petitions for her removal from office as Chief Justice. Inti the first thing Chief Justice no the kodai Supreme Court say ne ho adri no di enti na Chief Justice ne ho adri na wo se ono de emra abotro enkrata o te say president receive petition na otro enkrata ekokoma president say nanka president enfa petition embre no no nso mfa ne response enye den emra na emra otro san krata de koma president no sa time na no te say NPP MP Vincent Oko Asefua enso aba court Vincent Oko Asefua aba court say yemfa injunction into president ne so sa process na president peso ye no yemfa nto ne so inti Vincent Oko Asefua no can reasons into ono Chief Justice ye no wan say sa time na Vincent Eko Asefua eden sem no aba Supreme Court no so around that time ne so no te say His Excellency John Dramani Mahama released statement and a statement from the presidency award say they have found a prima facie case against ono the Chief Justice into ye no wan because susu say Vincent Eko Asefua e de asem akwa bedan court di enta na wo say Mahama Odi okwenim esanso eba beka se wa find prima facie nanka de wo se Mahama ye ne se nanka so ka se okay esan se Vincent Eko Asefua e de asem na banti me twen na Supreme Court the ruling aba enti Mahama ntwen e no de prima facie case and no this statement by say wa find a prima facie case. And so that's her first statement. I see the applicant further deposed that on the same day which was 22nd April 2025, she received a letter from the Office of the President informing her that a prima facie case has been established in respect of the 3 petitions for a removal as Chief Justice. That the letter also stated that a 5-member committee had been constituted to inquire into the petitions against her, and also communicated by suspension as Chief Justice pending the outcome of the committee's inquiry. The applicant bemoaned the processes triggered for her removal from office and contended that they violate various constitutional provisions and have gravely infringed on her fundamental rights. Osi Anchesa de na no sanso receive a letter from His Excellency John Dramani Mahama say indeed ya find the prima facie etiano na Mahama say or seti committee na committee no ya hwem na se wedi bone a ye beyi na free her as Chief Justice ono as Chief Justice no o say saa de na esi ye saa de na His Excellency John Dramani Mahama ye no etia ne fundamental human rights enti asemo a Chief Justice no air canon no. Now the third point ni o say furthermore the applicant deposed that the initiation of consultations between the President and the Council of State regarding her removal as Chief Justice, when she had neither been notified of the receipt of any petition nor had her comments been elicited in response to the allegations contained therein, constituted a violation of the constitutionally stipulated safeguards protecting the security of tenure of the Chief Justice and amounts to interference in the independence of the judiciary. Now, the third point in say, Sir, His Excellency John Dramani Mahama shall because I say Mahama she process na say ansa na wono eti ansa na wo ba betro ama His Excellency John Dramani Mahama say for petition e bre me na me so me fa me response mbra. Into I say Mahama she process na say Embra ono no wonim ho hwe ansa na later ye be ka atre ni nti no saa de na His Excellency John Dramani Mahama ye no a violation atre say eno no as Mahama interfere with the independence of the judiciary, a violation of a year or no the constitution are protected or no as a Chief Justice in the process no send your work no the consultation, that's the initiation of the consultation between the President and the Council of State, because on the or not say Mahama say one Council of State at Tenase and no more receive petition no more find prima facie on the osusu se na nke mbo na mane ansa na Mahama be kwa ye consultation with the Council of State inti saa de na Mahama ye no etia mra etia the processes. Also additionally she deposed that prior to her suspension, an opinion poll had purportedly been conducted by a pollster known to be close to the government, in which it was alleged that she was so unpopular that she had to be removed. She further deposed that there had been leaks of the petition and her responses to the public, and contending that the situation has fundamentally and irredeemably prejudiced both her case and the cases purportedly brought against her, and that no purpose would be served by holding the committee's proceedings in camera. She further contended that justice and fairness would rather be served by a public hearing of the petitions against her, as such a hearing would pose no harm to public morality, public safety, or public order. And you see, I think say Chief Justice Nankasano, I don't know, but but I'm surprised. Because over case I would in Supreme Court now. Utumi so no crown. Now I am confused, kakra. Now I'm telling you the reason why I think she's confused. Any. As some way I what can I say? Answer na ye be suspending or no. Was see obi ba online. Emma ni pa krono ba baby sa or onu na claim say enkrofo no ana ni pa krono eben aban. To obi a wo ben Mahama aban e ba online. Ena ni pa krono ba baby sa say Ghana foi Chief Justice no mo pesi yi na ma yen yi no ena Ghana fo bebre na no e kan se yen yi Chief Justice no ito no susu se saa de na esi ye no ama sebe case no kra no ono Chief Justice answer na ebedi case ne kra no ye di etia no saa de na esi ye no ama case na answer na ebedi case ne kra ye di etia no because akwa ye se nipa kro na oben aban no e ba be ye online poll no omo vote ni na akase yen yi Chief Justice no inti sa ne sa hunti constitution no eka say the removal of the Chief Justice process no Maya ma will be in no. Or say for fairness inti, yen fan to jano be in. Now the reason why I think say the Chief Justice, and maybe if we are going, I'll tell you, right? Let's go to more of the positions now we'll make here, no? Okay, and then I'll tell you why I think the Chief Justice was confused. Inti, with this relief and now with this statement, she was telling the court that the process, the committee never tenase no, ebedi na asem no. Yemma embra bedwem na Ghana fo ni na ehu because obi aye poll, online poll, ema ye ka say ye pese ye Chief Justice no. Nti eno hu nti yemma Ghana fo ni na ehu. This was her reasoning. Now Owie Noka said the applicant asserted further that the purported establishment of a prima facie case against her containing no reasoning was bereft of a judicious determination and simply fell far short of the requirements of a prima facie determination known to the Constitution and the laws of Ghana. Into what I say, prima facie ye find ye etiano no ababi anim reasoning be anim. There's no reason was it to me say you find a prima facie etiano. It falls short. I say basically that's what she's saying. I say, in consequence of the above, the applicant asserted that the determination by the president that a prima facie case has been established against her, as conveyed in the letter dated 22nd April 2025, together with the warrant of suspension served on her, constitute an unjust attempt to remove her as head of Ghana's judiciary and amounts to an undue infringement on the independence of the judiciary. It was based on the fact say ono na adwumu no susu say there is no reason I was a president it to me find a prima facie. There is no reason it to me I was say it to me case bibi any we trese we di bone. There is no reason e trese we di bone nti no. Based on that nti no. Removal na ye pese removing no an attack on the independence of the judiciary. Any kwan say was ye no. Nti basically no, according to the applicant, there is no committee properly and constitutionally constituted to inquire into the petitions for her removal as Chief Justice under Article 146 of the Constitution. As Justice Gabriel Scott Piaman, the named chairman, is not qualified to serve as either chairman or member of the said committee. No account of having adjudicated and delivered various rulings in favor of on account of having adjudicated and delivered various rulings in favor of one of the petitioners, Daniel Ofori, in actions filed in the Supreme Court, in which she was a member of the panel. Now we will come to this. But you see, where I was telling you, said the Chief Justice, were confused. Point 24 and point 26. And I'm going to take it again so you understand. Now, point 24, no, Chief Justice, ne say, the committee na ya set, you know. Movements na womo ejuma na womo ye no ayese ejuma no mo ye wokukum no o se maye nye ejuma no wokukum yemfa mbra abonti na obi ehu de nti a wo se obi a wo ben aban no akwa kobisa Ghana for say Chief Justice yenyi na e na Ghana for dodo na se yenyi no nti onu no susu say there is no fairness nti committee ni nti committee na ejuma a womo ye ni nti yembie mu na Ghana for hu in the first place. Technically, committee no enye aban. That committee na ye set ye no enye any arm of government. Omo ye select you omo no omo nya nkrophobia ebeka say omo ye government appointees. Inti eno kra na tre say ye boegu. But that is not even my point here. The point is that in one breath, and you see that was exactly what Judge Ajay Frimpong said. In one breath, asemwa wo kan say yema committee ne nkoso. Committee ejuma no yema ne nkoso. Nanso, yema nembra abonten no obi ehu. That is in point 24. And in point 26, asemwa wo kan say prima facie na yesi yenye etia ne nekra no reasoning bi enim nti asem ne yembongu. Nti committee ne mayema ne nye ejuma. Yen stop the process no mayema committee ne nye ejuma ne yembo asem ne go because there is no prima facie. There is no reasoning behind prima facie. I will say ya fine etia no. Or no answer in the previous point. Or see a committee in Yejuma. But Ejuma na see a committee in Yema Ghana for. That is why a Jeffrey Pon said, say, in one breath you are saying this, in another breath you are saying this. TCC are there now. Yema committee in Yejuma. And now say, Yembo assemblingu. On the judge ni bisasa question. And that is why I'm saying, say, the Chief Justice Nankasano, she was confused. Because when you're confused, you go with one. Ebia, menpese committee ni be juma. Cool. And committee ni nye juma die, a constitutional mandate, a constitutional duty, omunye omo juma. But me susu say juma na omo ye no omunye ni say. Yes, na no ni say you are focusing on one point. But also omunye way, also say omunye way. No, there na judges ni. So I felt like it was like on say Intiana Judge Amadou Tanko Eka say issues where not Chief Justice no reason no, they were just red herrings. Ati I say Bronika say red herrings and not say I say adie no ye be yimi inti menye de meye bia na ase menhye dan confuse yomo. That's what the judge said, Amadou Tanko, in his ruling. That's what he said. And clearly you understand why the judge was saying that. And see what I say. Now, point 27 no. As someone what can I say? According to the applicant, there is no committee properly. Or say, committee be anywhere between Yatena or non assem so. And I don't understand why she's saying this, because Article 146 clearly states, say the president should set up a committee. And that committee, and I mean, we've read Article 147, we've read it on several occasions, but it is good that we read it again. It's good that we'll read it again. It's good that we read it again so that people see, because the Chief Justice is saying, say, there is no committee properly set to sit on her removal. And Obabebo Justice Piamai Edin. But Justice Piamai Samuel Walker, so we'll get to that. But let's read Article 146 and see. Say, indeed, committee be anywhere constitution, they say, yen seti, say, Antenna Chief Justice in case one. Any, or say, while the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, and this is Article 1466, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. So, the Constitution in Article 146 clearly states that in the removal of the Chief Justice, the President shall appoint a committee, 2 judges every womb. And that is exactly what the President has done. And so if the Chief Justice is saying, say, there is no constitution or there is no committee that is properly and constitutionally constituted to inquire into the petition of the removal of the Chief Justice, what are you saying? What does Article 146 say? I say in the removal of the Chief Justice, there should be a committee. It is also ye Chief Justice a committee be anywhere. And then I will try Ghana for. Obi be say Chiaka say inti mami no ni memra na. And if the person asks that question, nipa kono waiting. A genuine question. Now, Owie no sanso ka say Judge Bakwa wati case ni so your friend Justice Gabriel Scott Pierman. Or say ye Scott Pierman free committee ni so. DNTR, one of the petitioners a friend Daniel Ofori, and people who know Daniel Ofori, I mean, this is just on the other side. If Uyobia will invest in the Ghanaian stock exchange, stock market, right? Now you like investing in banks. Okay, there are some people who like, I mean, Oba Ghana stock exchange, there are banks, if you want to invest in the banking sector, you want to invest in maybe agri sector, you have the benzo oil production and the likes, what you say. But Oshe, the banking sector, no, Oshe will be a major player in them. A major shareholder in some of the banks, like, even Ghana Commercial Bank, Daniel Ofori. Daniel Ofori is a shareholder, a major shareholder, and he's a big player in the Ghanaian stock exchange. What you say? Until you be investing in the Ghanaian stock exchange. Now, person on the background. Now we show more investing in some of our banks. Daniel Ofori is one of those people. So into onye small man, he's a big investor in the Ghanaian businesses. Into I say Daniel Ofori no. Our cases be bring Supreme Court. Now cases be bring Daniel Ofori our Supreme Court hono. Judge Pierman atena cases ne so a most often no Judge Pierman edi case no Emma Daniel Ofori. Inti enu hunti si yete committee na Judge Pierman no ete so a. E likely say Judge Pierman ebedi ama Daniel Ofori ebiom because Daniel Ofori ne pesi ye you no chief justice no nti enu hunti Judge Piaman no eni kwan se wo so. And you see saa de we ya chief justice no e kan ye no, for me it has really exposed the mentality of the suspended chief justice. I'm not going to lie, because tio me pese obiati as you see we have been made to believe and understand in Ghana say judges di asem a omudi asem based on the evidence, the fact in front of them. Okay, inti yemfa ne say meni obi enya asem asase ho manso na me, okay, ena asase ne ye media na media court na judge bi ahwe evidence na wedi ama me na masanso enya asem foforo ati ase ebia wo bi de meka na media court na judge di asem na mame na ebia there is a third case I no masem enya de. Okay, me need evidence. Now, so obejina baby na oka say two of me cases na na sem yede. I me what evidence a judge no edima me no. Say there is a third case. Na no need me need evidence. Now oka say because judge need the two of the cases a mame. Ah na me what evidence no. Until there is a third case me need evidence. And no still judge be dia mamia. You see, you are insulting the intelligence of the judge. And you as a judge, Krano, you've also exposed wo mentality. Because Obianim say the judges are ruling based on evidence. Until say MPP for by Ghana for na be hu say judges no be bring na no the emotions and na mo the ruling. But ordinarily no Ghana for them say the judges are ruling based on evidence. It is what say Judge Piaman cases be bring Daniel Ofori e the Aba Supreme Court. Judge Piaman edi Emma Daniel Ofori. Inti wonsu case we aba no Judge Piaman be di Emma Daniel Ofori. Not just say why expose with the Judge Piaman atem with the or no Judge Piaman with the atem o tre say o ta was swear say obey candid and fair and honest in applying the law no o be say Judge Piaman on yes ade no. And you've also exposed wo in the sense that probably maybe you see sometimes the people will tell you say we project our mentalities on people. Into obi asebe o taifa ne yiri echi say bia o friend ano obi o taifa ne girl echi. Say bria our friend a girl na bia wanya na eya na ye say the girl den so fa na chi. What I say because you are projecting what you do on other people. Obi a wotai twantro. So obi ne kasa eya na ye say nipa ko nso twantro. Normally no you are projecting the oye etu obi so. And so if you are telling us say Judge Piaman because with the cases ama eye Daniel Ofori. Na wo nso ne Daniel Ofori nya asem na mo ba Judge Piaman enim enu hunti obedi ama Daniel Ofori o expose wo mentality na tese wo ma me na embra na wo ye chief justice na wo ye judge no na wo di case based on familiarity with people into di case ma MPP for a basically no assets na wo kan so wo di cases ma MPP for a later MPP for back quarter wo hwe say omo evidence ho ana evidence ni ho obedi ama omo. And that is why you are worried. Walker say, yenyi Judge Piaman because who feel say or no be yosa. That could be the only explanation. Because point 27 na mami or my no. It is a serious attempt on the integrity of the judges in this country and the integrity of the Supreme Court Judge Piaman. A serious attempt serious. Na me they say, all the judgments are ready here. As a judges, no, they didn't want to descend there. They didn't want to go there because Utmun say, says asem the can ne yo muhi, but no more person be bosso. Asem chief justice ne kan no. Atiase. Now, point 28. I say in respect of Justice Samuel Kwame Adibu Asiedu, the applicant contended that he is also not qualified to serve as a member of the committee set by the president on account of having already sat as a member of panel of the Supreme Court constituted under Article 1282 of the Constitution to hear an application for interlocutory injunction filed by Vincent Eko Asefua. Consequently, the said appointment of Justice Asiedu violates the independence of the judiciary. It was also per se or trese justice once the Constitution is a two judges and so. To address the second judge, a friend of justice, Samuel Kwame Adibuno, or not na case na ye bo Asefua ne nsɛm ni gu ye no ɔtena saa case ne so it is a wabo asefo ansɛm egu a eni kwan so ɔtena ono chief justice no so na asɛm so. And you see saa deɛ we that chief justice ne ka ni na no sɛnea meka no she is rather insulting her colleagues, telling them that they cannot be fair, because we all know in this country say judges etina more than one case so judges etina different cases so, and we expect them to be fair on all the cases. It is a worker say judge bi atina asefo case so we dietia asefo into obetina wo de so na no so trese wo be dietia wo de, then you are insulting the judiciary in this country. Not just as a chief justice no, now when him say judges na mo nya fair, but what did you do about it as chief justice? Because now you are afraid of your own colleagues, and you are saying say you don't think they will be fair on your case. Now say be would the asempa and anka judges mo ye fair, na nka obeka same way etia wa colleagues unim say judges mo ye fair, na nka obeka same way etia wa colleagues. I just say the woman is saying something about the judiciary, she's saying something about the Supreme Court judges, and for me all these points she's saying, no, all these points she's making, no, it's even reason enough, for the Chief Justice to leave, so that at least there will be some reset at the judiciary. Because if the current Chief Justice, suspended Chief Justice, thinks this way about 2 Supreme Court judges, then there's something wrong at the Supreme Court. We need new leadership, or better say, Supreme Court. No, basically that's what I think. Point 29. I say, with respect to the other respondents, the applicants allege that not having taken the oath as required by law, they were not qualified to be members of the committee and thus could not discharge the functions constitutionally entrusted to them as of their first sitting on 15th May 2025. The other 3 people are on say constitution can say yefa 2 Supreme Court judges are yenfa other people any or say committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the president, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. It is our other 3 people, no, and our all say, omo swear oath, inti they don't, omo swear oath here, and so they don't qualify to be on the committee. But no crano, the Attorney General's office opposed that. So that time the Nipakwa would be or case in so Justice Remside. So Justice Remside opposed that, and then rather said, say those people almost swore, they swore an oath. Into Chief Justice, because someone swore oath, not as a Chief Justice in Uchantro, right? Now, I see, in consequence of the above depositions, the applicant asserted that irreparable damage and grave injury will be occasioned to her good self and the people of Ghana if the committee proceeds with a tainted process. And so basically, we have Chief Justice in the case, now will raise it. And someone what they call that in Supreme Court in him, no any. Make me lawyer cry. What they say we have two in him. I believe say dear we ever more unanimous. Ever. Hey, Yawajo, I said penny. It's MPP for upon all moon. You were lawyers, no. Godfrey Dami Edi Chief Justice in him Echo Court say yembo a constitutionally mandated duty enguno. Na monsema modiko 2 Supreme Court judges in him. And you were expecting say case where modiko 2 Supreme Court judges in him, no, they will find merit in it and grant you your release. Wow. Because me melodies I mean law, main call law school crana. Me cran and someone more kind of cran, I am able to counter them. Even with the law, in someone will raise and then may be a constitution, and I may counter and say no. I am even able to counter them with the law. And to think that the Chief Justice, our law field, no, for so many years, this was the issue, the best she could raise. Because mind you, and so or the Assembly Court Supreme Court, you expect that she will raise a solid case. So the best case, sitting down with Godfrey Dami and probably with getting help from MPP lawyers and the likes. I don't know whether she indeed got help or not. But sitting down with Godfrey Dami and getting help, allegedly, from MPP lawyers, no, this is the best they could present to the Supreme Court. Say no hunti yembo process ningu. This is the best they could present. Hey, I'm shocked. I am really surprised. I'm not going to lie to you. I'm surprised. Because I was expecting, case no tough for me, and no one say, okay, I mean, a raise issue. But issues when on the call here, they are. How? When naka judge be wo na judge ne ka say no my chief justice no one impu na adane for one na nka sa judge was see a question no because in same way a chief justice aba to Supreme Court in no in same way any yen hwe so na won rule how in some way raise ni na no say obi aye obi ben aban and waye online poll no ye ka se yen yi minti no eno hu nti aban adwuma bi a wo ye na how can you how you go to a Supreme Court with hearsay with something like that? Oh, Charlie. Na nipa kro we judge we a wotina we case ni so no de bia nipa kro we na semba Supreme Court a judge o di nipa ko na semma ni nti nde ma semma aba ne nipa ko no be dia ma say ni how Supreme Court judge Chief Justice he speak like this anyway. What try your comment box ni mo me da say